Be interesting.
All right, good evening.
Yeah.
Good evening.
Correct. Yes, I do.
So I'm Mike Carroll. I'm the director in the program on information justice and intellectual property. On behalf of Dean Nelson, I want to welcome everyone to the Washington College of Law. It's great to see so many family and friends of the IP program here, and recent graduates and more distant graduates, but welcome home. So I am going to quickly get out of the way. I think most of you know about our program and what we've done, but we have this annual lecture that we have named after our distinguished colleague, Peter Jaszi, in order to bring our community together and focus attention on an issue of interest in the field. I'm very delighted that Rebecca Tushnet, now professor at Harvard Law School, has agreed to join us. She's been a longtime friend of the program, as Peter will elaborate in a few minutes. We've just, to make everything clear, while Peter is now titled Professor Emeritus, that's actually mislabeling, it's false advertising, because in fact he's an active member of our program, and we're thrilled and proud about that. And so I'm going to ask Peter to actually come up and introduce our speaker, and with that, Professor Jaszi.
Thank you so much.
So a few years back, when I was first told of my colleague's rash initiative to honor me with this eponymous lecture series, the news inspired, obviously, deep gratitude, and I'll admit some feelings of ambivalence. And I'll never get over the former. I remain as grateful as ever. But I think I've more or less recovered from the latter, because I've discovered some of the advantages that come along with this occasion. One of which is that it gives me a legitimate reason to try to use the word eponymous in a sentence. The other is that as things worked out, we've been able to take advantage of this series to welcome a number of very distinguished outside lecturers who just happen to be, coincidentally or not, members of my own personal and professional pantheon. So we've had Professors Chris Sprigman and Bernd Hugenholtz and Pam Samuelson and William Fisher and Judge Pierre Laval, all of whom are outsized figures whose work combines profound expertise with a wise understanding of the social functions and occasional dysfunctions of intellectual property. And this year, that tradition continues as Professor Rebecca Tushnet, who is now holding forth at Harvard Law School and was immediately before that our crosstown colleague at Georgetown Law, honors us with a talk. I mention Professor Tushnet's prior affiliation as well as her present one because during her decade at Georgetown, she earned not only the general admiration of the Legal Academy and of her many grateful students, but also that of the Washington, D.C. based public interest IP community. And over the same period, I hope, not coincidentally, she proved, as Mike has already suggested, to be an enormously faithful friend of our own program on information justice and intellectual property, as a welcome fixture at our various activities and a particular supporter of the annual IP gender workshops, and as a valued advisor to a variety of advocacy campaigns that have had their centers here. We haven't been unique in being the beneficiaries of Professor Tushnet's intellectual generosity. Indeed, all of her professional work reflects the high value she attaches to openness and sharing. This core value helps to explain her indefatigable efforts in creating and maintaining her 43 blog, Tushnet blogspot.com, as well as the absolutely indispensable, at least if you happen to be an IP pedagogue, Georgetown IP teaching database. It also helps to account, and this is something very close to my heart, for her role in launching the Organization for Transformative Works, which has become an essential, perhaps the essential resource for makers of all kinds of fan culture, to say nothing, of course, of her many direct interventions in the policy process, including the Organization for Transformative Work's successful campaign to win new space for fan culture in the Section 1201 anti-circumvention rulemaking. So, it probably goes without saying that Professor Tushnet is celebrated by all who have had the privilege to work with her, and she is widely and generally respected as well by those who have only had the good fortune to be touched by her voluminous, witty, brave, wide-ranging, and influential published scholarship. In this body of work, she wears her expertise lightly and wields a sharply fashioned pen poised to puncture and even sometimes deflate orthodoxies of every kind. And she never, never loses sight of the ways in which collective choices about the regulation of knowledge and its circulation produce real consequences for individuals and collectivities. But wait, as the long-form infomercials would have it, there's more. The bright thread running through all Professor Tushnet's work is her commitment to the open circulation of information, a theme appropriately recognized in her new professorial designation as the Frank M. Stenton Professor of First Amendment Law. Those of us who have known her in connection with our own narrow scholarly preoccupations in fields like copyright and trademark may sometimes have lost sight of her other specialties, such as advertising law, which she'll be discussing this evening, but we've never been in any doubt about her dedication to examining the legal and societal conditions around freedom of expression, an inquiry which supplies the other dimension of tonight's topic. So, for myself, on behalf of WCL and of PIDGIP, it's my special pleasure to give you Professor Rebecca Tushnet. Thank you.
Thank you for coming out. No one has ever accused me of imposter syndrome, so I will hesitate to admit it's still a little hard to listen to that. I still wonder who they're talking about. I want to thank Peter as well as everyone at AU. My side of the story is that Peter and his colleagues were incredibly welcoming to me from the moment I showed up. I was lucky to watch as they built a fantastic clinic and did great work with it. Also great work in the fair use best practices with both in the law school and working with Patricia Aufderheide. The people at AU have been an amazing example of unfailing enthusiasm for law and for justice. And I take the WCL community as a model of a scholarly community where people are deeply engaged. I can't beat Peter for humor, so I'm not going to try, but I will try and honor him with a robust discussion of ideas. And I give you fair warning, these are relatively preliminary thoughts I've been trying to pull together. I've been wrong before, so what I'm trying to do is talk about a trend I see in some First Amendment commercial speech cases and what it might mean for the future of regulation, regulation of advertising, possibly regulation of trademarks. So let me start by saying you may well wonder what I'm doing talking about consumer protection and false advertising in a lecture that's typically focused on intellectual property. My background is in the Lanham Act, the federal false advertising and trademark statute, and trademark and false advertising principles are often similar, if not the same. I, in fact, prefer to think of trademark infringement as a kind of false advertising. It is a false claim to attributes that the consumer wishes to have, in the case of trademark, source or perhaps occasionally sponsorship. protecting trademark owners against infringement can also protect consumers against deception, just as other consumer protection laws do. But if trademark is a branch of advertising law, or even just closely related, then people interested in trademark need to pay attention to what's going on with advertising law in general. And the news ought to be disturbing. As I'm sure you all know, the Supreme Court recently struck down one provision of the Lanham Act in Mattel versus Tam. It didn't reach the arguments about the relationship between commercial speech and trademark laws, but had it done so, it would have faced a number of serious questions. Does trademark law regulate only commercial speech? Even if that's the case, does every provision of trademark law satisfy the central Hudson test, which courts presently use to evaluate regulations of commercial speech? The interest in protecting consumers against deception is certainly substantial, but does, for example, dilution do anything nearly that important? What about the ban on registering governmental insignia? Central Hudson looks not only for a substantial government interest, but also for proof that the regulation actually furthers that substantial government interest and is no more restrictive than necessary, something the drafters of the Lanham Act had no concern at all for when they were writing. So about 15 years ago, in a case called Nike versus Caskey, the Supreme Court ducked the issue of the compatibility of advertising law writ large with aggressive views of the First Amendment. But subsequent decisions by the court and the courts of appeals have reinvigorated challengers to the regulatory state, from the FDA to the FCC and everywhere in between. I'm going to describe a couple cases indicating the state of play in commercial speech, and I'm going to talk about the epistemology of the First Amendment. I don't intend to drown you in jargon. It's my contention that thinking specifically about epistemology, how it is that we know what we know, is crucial to understanding both the current increase in First Amendment scrutiny of consumer protection regulation and the reason that ultimately consumer protection regulation should largely survive that scrutiny. If we think that legislatures and administrative agencies can legitimately find facts about the general state of the world, and I think we should think that, then consumer protection should survive the current assaults, which is not to say that it will. We're in an age of judicial distrust of other fact finders, combined with confidence in a court's own ability to find facts. The resulting product is a confusing mix of relativism and certainty that tends to tilt against consumer protection. In fact, my first two examples of what's going on aren't First Amendment commercial speech cases, but they provide some important local color, I think. A couple of weeks ago, Chief Justice John Roberts called sociology gobbledygook. This is a double statement of contempt, given that the rigorous empirical model he was criticizing didn't even come from sociology. It was a political science product. Within a few days, another judge, this one from the Southern District of New York, struck a different but related blow at normal science. There's a case, FTC versus Quincy Bioscience. The court dismissed a complaint brought by the FTC and New York's Attorney General, reasoning that as long as the advertiser had one study that arguably supported its claim for its brain-boosting supplement, it wasn't plausibly engaged in false advertising. Even though the study only partially supported its claim, and that partial support was only because of post hoc subgrouping. So post hoc subgrouping is the practice of looking for statistically significant results in subsets of a study population. Post hoc, because you're looking for positive results, you're combing through the data in subgroups that you initially had no particular reason to suspect of being special. Among the risks of post hoc subgrouping is the increased chance of false positives. So false positives are results that look like they support your hypothesis, but in fact they're just the result of random error. Mathematically, you expect a certain number of false positives when you run an experiment enough times, and the true result is negative. There's a very good book about this kind of statistical manipulation in biomedical studies, a book called Rigor Mortis, which I highly recommend to the interested. But the judge didn't understand the statistics. He thought a positive result in a subgroup was persuasive evidence that something real in the supplement was actually causing improved cognitive functioning in that subgroup. So persuasive, in fact, that the contrary conclusion that this was a false positive, although statistically more likely, was implausible for purposes of a motion to dismiss. The judge in the Quincy Bio case demonstrated ignorance, Chief Roberts' contempt for facts, I think, is strategic, but both incidents show a rejection of ways of knowing that don't come from a courtroom clash of witnesses to individual events. But because legislation and regulation work by taking lessons from aggregates, even if legislators too often treat anecdotes as data, a hostility to statistically derived knowledge inherently disadvantages the practice of legislation and of administrative regulation. And even, not coincidentally, the practice of aggregating individual wrongs known as the class action. This isn't simply a matter of distinguishing between what has long been called the difference between adjudicative facts and legislative facts. According to the federal rules of evidence, adjudicative facts are the facts of the particular case. So who did what to whom? Legislative facts, on the other hand, are those which have relevance to legal reasoning and the lawmaking process, whether in the formulation of a legal principle or ruling by a judge or court or in the enactment of a legislative body. So as you can see, the federal rules of evidence contemplate that there's a set of things called legislative facts that courts will be dealing with on a regular and finding on a regular basis. Adjudicative facts are typically seen as retrospective and isolated. So one thing actually happened, other things did not. Legislative facts can be predictive and probabilistic. Social science is one common source of modern legislative facts. Biology, engineering, and other disciplines regularly also participate. And advertising cases involve legislative facts. For example, is it misleading to reasonable consumers to advertise only a cash price and then charge a surcharge when you pull out your credit card at the register? A theory of what constitutes reasonability in a consumer and how reasonable consumers perceive the world is a theory that produces legislative facts, as does a theory of what reasonable consumers would consider material in their purchasing decisions. Current First Amendment doctrine is relatively hostile to legislature's findings of this kind of legislative fact, but I think that's an aspect of the broader fight over knowledge and how knowledge is identified and applied. Especially since what counts as a legislative fact versus an adjudicative fact is incredibly flexible and context dependent. The problem's heightened in the area of commercial speech, I think, because in theory, when evaluating the First Amendment restraints on commercial speech regulation, courts are applying what is at least close to intermediate scrutiny. There are debates about how you should characterize it as a kind of intermediate scrutiny, but intermediate scrutiny is where this kind of fact is the most important. Rational basis scrutiny gives so much leeway to the legislature that it hardly matters how good they've been at fact-finding. Strict scrutiny disfavors regulation so much that fact-finding, again, rarely matters. It's intermediate scrutiny where the hottest judicial debates over whether the legislature got it right take place. Now, a lot of scholars have identified a problem of so-called First Amendment Lochnerism, which is striking down economic regulations that in 100 years ago would have been struck down under the due process principles of Lochner in the name of the Constitution, but this time in the name of the First Amendment. So using freedom of speech to prevent regulation of economic activity where speech is, as it is so often, the mode of setting up and carrying out that economic activity. Recent Supreme Court cases that have drawn this objection include Sorrell versus INS, which struck down a state's attempt to reduce the influence of drug detailers and the gifts they often bring on the prescriptions that doctors write. And of course, there was just a study the other day that came out showing that the more you visit and the more money you pay to doctors, the more expensive the prescriptions are that they write. So even if it's not conscious, there's clearly an issue happening here. Similarly, last term, there was the Schneiderman case suggesting that there were First Amendment infirmities in New York's attempt to regulate the advertising of cash discounts versus credit surcharge policies at stores. This is an economic policy, but it is perceivable as a First Amendment problem because of the expansion of First Amendment doctrine over the years. There are even more of these at the lower court level, including a ruling that giving out free gifts to promote cigarettes is an exercise of free speech rights. But Lochner, as we now understand it, was about power, the judicial power to prevent the legislature from enacting laws that redistribute economic power because of supposedly neutral and fact-indifferent principles. So when Lochner was finally rejected, we end up with the famous Caroline Products footnote indicating that we'll defer to Congress, but less when the legislature is disadvantaging historically powerless groups or discrete and insular minorities. The new form of First Amendment anti-regulationism is often premised on a different conceptual hook, knowledge, which then mediates how power can be exercised. So, for an example, the Ninth Circuit recently struck down San Francisco's attempt to get soda sellers to disclose that sugary drinks contribute to obesity. And the ground of decision was that the disclosure was itself misleading. You could, in theory, require such a disclosure, the reasoning goes, if you could prove that there was a special causal connection between soda and obesity, but you didn't, so you can't. And the First Amendment counsels skepticism of fact-finding that leads to regulations on speech, which is why the government has a burden of proof here far beyond rational basis scrutiny. Similarly, the Second Circuit held that it was unconstitutional for the FDA to prevent drug makers from making claims about their drugs that the FDA hadn't approved unless the FDA affirmatively proved the claims false, rather than that the claims simply hadn't met the FDA's standards for scientific proof, at least when the claims are made to doctors. We're still willing to exercise more control over the proles. The claims in theory could be banned, but again, only on better evidence than the FDA had offered. One reason I think, or I speculate, that this kind of questioning of the foundations of regulation has not as yet led to the general invalidation of most consumer protection laws, including most of the the Food and Drug Administration governing statute and the FTC Act that deals with consumer protection, is that there's a tension between these knowledge claims, or lack of knowledge claims, that is vaguely sensed but not fully worked out in the cases. And it's this. We all know the classic line from early in the Supreme Court's history, it's emphatically the province of the judicial branch to say what the law is. But it's almost as accurate to say it's emphatically the province of the judicial branch to say what the facts are. That is, even if the fact-finding enterprise is occasionally shared with the other branches, resolving most cases requires some sort of statement about their facts. And if we are truly in a state of epistemological uncertainty that the current First Amendment regulatory skepticism gestures towards, then nobody in government should be finding facts, courts being agents of government too. So consider this. Under current First Amendment doctrine, at least in the Second Circuit, a drug maker can make these claims for which it has support in at least one decent study. It makes the claims, a patient takes the drug, patient dies. It's perfectly possible that current tort doctrine would allow a successful products liability claim against the drug maker based on the same standards of knowledge that the FDA tried but was not allowed to invoke to protect its restriction on promotional speech. A Lachnerian analysis, one that invoked pure concepts instead of burdens of proof, could reconcile this tension very easily. Most speech we don't allow prior restraints on, even when we allow subsequent punishment for that very speech. So if we applied prior restraint doctrine to commercial speech, we currently don't, but we could, we'd have no First Amendment problem with the products liability verdict. But the Second Circuit analysis that we have rests on very different foundations. That analysis is about how the FDA determines that speech is untrue or misleading. And thus, if we say that the FDA hasn't proved its case to prohibit the safety and efficacy claims for the drug, but we don't bar the product's liability claim, we have two holdings in severe tension, if not in direct conflict, making claims about the state of the world. So Denise Esposito, a former chief of staff of the commissioner of the FDA, asked this outright. The question is, who is the arbiter of good science? A judge can use Daubert to keep science out of the courtroom, but the FDA considers itself to be the arbiter of safety and effectiveness because that's its job. And there are institutional reasons why it might seek to increase its own power, but at the same time, it is institutionally capable of doing better statistical analyses than courts largely are. So courts, well, another way to resolve the tension would be to deny my second premise. Perhaps the First Amendment should preclude many product liability claims. especially those that involve a clash of expert testimony. If the experts can't agree, maybe there's enough uncertainty to allow the claim to be made or the product to be marketed. And indeed, this is actually the standard that the Fourth Circuit has adopted for false advertising claims about efficacy of supplements, that unless all scientists would agree that the claim is false, it's not false. So the position that says, okay, then there are no products liability claims either, has, I think, the virtue of consistency, but it's a blueprint for a truly terrible world. A 19th century world where businesses are essentially never liable for the harm they do to their customers or their employees, where the doctrine promises redress in theory, but never allows liability in reality because of claims about inability to determine the facts of the matter. Courts, though, like to determine facts. They like to resolve cases. So although the current strain of First Amendment libertarianism often denies the power to determine facts to co-equal branches of government, courts haven't generally applied the same sort of skepticism to their own fact-finding abilities. And so their claims of epistemological uncertainty, not knowing how to know, are deployed selectively, retaining their power to make factual findings, for example, that consumers might have been deceived by specific claims, while often denying the power to other regulators to do the same thing, or to make rules more specific than a general ban on false or misleading commercial speech. So, for example, last year the 11th Circuit invalidated a state law that governed how dairy products had to be labeled. I learned from the case that skimming the cream from milk, that is, creating skim milk, removes almost all the vitamin A. It's thus standard for governments to require that vitamin A be added back in to skim milk because consumers don't know this and think they're getting the same nutrition except for the fat when it's skimmed. Turns out vitamin A is fat soluble. You learn something new every day. So Florida did not ban the sale of vitamin A-less skim milk outright, but it didn't allow it to be called skim milk. The court struck down this rule, reasoning that the state couldn't simply define skim milk as milk with the cream removed and vitamin A added, which is what it had tried to do. The court said it's undoubtedly true that a state can propose a definition for a given term. However, it does not follow that once a state has done so, any use of the term inconsistent with the state's preferred definition is inherently misleading. Such a per se rule would eviscerate Central Hudson, rendering all but the threshold question of whether the commercial speech was misleading or false superfluous. All a state would need to do in order to regulate speech would be to redefine the pertinent language in accordance with its regulatory goals. Then all usage in conflict with the regulatory agenda would be inherently misleading. One thing here is the court indicated its lack of consideration of the wide range of speech regulations evaluated under Central Hudson, including the one at issue in Central Hudson itself, many of which could not be evaded by establishing a state standardized meaning for a term. So in Central Hudson, they were trying to regulate the amount of advertising designed to get people to consume more power. It's very difficult to imagine how state definitions could have made that misleading. But for my purposes here, I think it's also important that in the 11th Circuit's conception, the state, in the form of the legislature, and presumably administrators too, can only propose a definition for a given term. It can't enforce that definition because the courts will ultimately determine which other definitions are also appropriate. The court goes on to say that it's possible the state's definition will become standard, in which case contradictory uses will be misleading. But of course, denying the state the power to enforce its definition makes that standardization much less likely. We have all around us terms that are standard because the government set the terms, like miles per gallon and organic, but those developed with sanctions if you didn't do it the government's way, in a regime that the 11th Circuit now apparently considers unconstitutional. So whether other terms will standardize themselves when the government can no longer enforce them, it's not obvious at the very least. And indeed, the 11th Circuit went on to say that calling the dairy's product skim milk, in this case, was a statement of objective fact, relying on dictionary definitions, which I have to say rarely have occasion to discuss vitamin content. And the court further said that statements of objective fact will only be inherently misleading and thus subject to being banned in rare cases. So the court is still actually insisting on its power to determine objective fact. Going further, the court rejected the state's evidence that the dairy's labeling was misleading. The state had submitted a survey indicating that consumers expect skim milk to have the same vitamin content as whole milk. That wasn't enough, according to the court, because it reasoned that the state study provides no evidence that consumers expected anything other than skim milk. You will recall the court has previously defined skim milk to be milk with the cream removed, with no further information about vitamin content, when they read these words on the creamery's bottles. And the statement is charitably nonsense. Consumers haven't had occasion to pull apart the components of skim milk with which they're familiar, given the existence of the regulation everywhere but now in Florida. They don't know, as that survey showed, that there's any difference between skim milk and skim milk with the same vitamins as whole milk. That's why the state required the regulation in the first place, because consumers were being deceived about what they were buying based on their assumptions, which, weren't based in science, but that's because they didn't know the science of vitamin A. For my purposes, the most important part of the holding is the epistemological one, the inability of the legislature to make reasonable inferences from empirical data like this survey, corresponding to the court's power to require more evidence. Now, I'm going to give a counterexample. This is a judge who doesn't want anyone in government to make factual findings. And I think doing so, she demonstrates why the nobody can make factual findings is very, very difficult to sustain as a matter of First Amendment doctrine and as a theory of government. This is a case in which the DC Circuit upheld a Department of Agriculture requirement that meat has to be labeled by country of origin against a First Amendment challenge by the American Meat Institute. Judge Brown dissented from the majority in an opinion I find completely incoherent, but very interestingly so. So near the end of the opinion, she says, there can be no right not to speak when the government may compel its citizens to act as mouthpieces for whatever it deems factual and non-controversial, and the determination of what is and what is not is left to the subjective and ad hoc whims of government bureaucrats or judges. In a world in which the existence of truth and objective reality are daily denied and unverifiable hypotheses are deemed indisputable, what is claimed as fact may owe more to faith than science. On one reading of this claim, SEC disclosure requirements, FTC consumer protection regulation, and most of what the FDA does is equally unconstitutional, since only the speaker should decide for herself what facts are true. Previously in the opinion, though, Judge Brown had expressed support, at least in theory, for prohibitions on truly false advertising. So she seems to have some concept of facts that can legitimately be found. Nor does she make clear why, if judges' determinations of facts are subjective and ad hoc, we let them, including her, make decisions at all. Her screed against fact-finding is particularly notable because she isn't dismissing statistics, she isn't dismissing sociology, she's discussing the facts of the physical origin of particular cows. It may be expensive to find out where a particular cow is from, which is the real reason that the AMI was suing to have the regulation invalidated. But it doesn't require the use of the methods of any scientific discipline. If she is truly taking the position that whether a cow was born in Mexico or Canada is fundamentally indeterminate and potentially controversial, right? Then the project of seeking truth, which I think of as one key function of the judicial system, is hopeless. And even if you say it's not seeking truth, it's seeking resolution, right? Or some social settlement. That project too becomes hopeless if we can't figure out where a cow is from. I understand that radical uncertainty about facts has utility as a political position. It has strategic benefits for certain groups, but I don't think it's a position that a judge should hold. Once you abandon empirical fact-finding, ideology really is the only alternative. And this, I think, is another connection to Lochnerism. And yes, I believe in motivated cognition. I engage in motivated cognition. So it's certainly not the case that it's really easy to find out the facts of any given situation. And it's definitely the case that what we want to believe shapes what supposed facts we find credible. This is certainly also true of our legislatures and of our administrators and of our courts. But if we say that the state is just incompetent to find facts, that just logically abandons the project of fact-finding entirely and the aspiration of finding ways to look beyond our preconceptions, which I think is possible. So unlike Judge Brown, many judges remain perfectly confident of their own ability to find facts in individual cases, and at the same time contemptuous of legislatures and regulators' findings, whether wholesale or retail. I think they manage that trick not only by holding themselves free of the biases that they so easily see in everyone else. That's an ordinary human practice. But also by limiting their concepts of provable facts to causal stories that wholly explain individual events, and dismissing probabilistic and aggregated evidence when that evidence is used to support regulation. For example, evidence about the relationship between violent video games and violent acts. A couple other ways in which judges exercise their special power to divine the truth. One that's of particular interest to me is in striking down the FDA's graphic cigarette warnings. The DC Circuit panel split over whether visual warnings, so for example, showing a body on an autopsy table, were purely factual and uncontroversial. And the majority characterized the visual images, someone with a hole cut in their esophagus to breathe because of throat cancer. That's not purely factual because it's primarily intended to evoke an emotional response. This analysis is just wrong in a number of ways. As the dissent pointed out, emotion and facts are linked, they're not opposites. And the fact that cigarettes substantially increase your risk of dying horribly predictably makes people feel bad. And so it's not like a surprise that truthful information is associated with emotions. Empirical research on the warnings at issue indicate that consumers generally did receive a factual message from them, not a non-factual message. But the judges in the majority had no trouble determining for themselves what the images actually meant, and they used that interpretive power to find that the images conveyed the wrong messages to consumers. They're not alone. Not too long ago, in the recent sugar-sweetened beverages case, the Ninth Circuit had no problem deciding that a disclosure saying there's a link between sugar-sweetened beverages and obesity was really saying that there's something especially dangerous about sugar-sweetened beverages, regardless of one's other lifestyle choices or calorie consumption. So, one thing you might say in response to my criticisms of what I might call the court's arrogance or aggregation of interpretive power about facts to itself is that there are real questions about the relative ability of courts and legislatures or agencies to find facts of this type. So the group-based biases that Caroline Products footnote 4 identifies work their way into motivated reasoning about facts. One path forward, though, is at least to consider what sorts of differential motivated reasoning we ought to be looking out for, what they are as between courts and legislatures and agencies. For judges, ideological commitments may actually be playing a stronger role today than they did in earlier periods, given the general increase in partisanship. And that may counsel at least a kind of interpretive modesty in many cases. For agencies, there's commitment to the agency's mission, whatever the current administration defines that mission to be. That may influence fact-finding. For legislatures, standard interest group accounts say interest group influenced assessments of facts is likely to be the primary driver of motivated fact-finding. Each version has its own risks and rewards, and I don't want to discount that. But courts err when they hold themselves exempt from the scrutiny that they give to others. And we need to have a real conversation about when courts are not the best fact finders, and the legislature and or an agency has engaged in a fact finding procedure. So my diagnosis is a crisis of epistemology used to convert the First Amendment into a weapon against economic regulations. I want to, as I end, take it back towards intellectual property, because it's useful to consider how it is that we know that trademark infringement and counterfeiting harm consumers. Even if we know that in general, or in the aggregate, could we prove that such harm had actually materialized in a particular case? I wouldn't be so sure. There's a case from the DC Circuit last year that I find quite telling. The Federal Election Commission prohibits unauthorized political committees. The plaintiff here is Pursuing America's Greatness, from using candidates' names in the titles of their websites and social media pages. There's an exception that allows unauthorized committees to use candidate names when the name is unambiguously showing opposition to the candidate, because the potential for fraud and abuse in that case is substantially reduced. But the plaintiff didn't want to do that. In fact, the plaintiff, Pursuing America's Greatness, supported Governor Huckabee in his most recent run for the White House. So they created a website and a Facebook page called I Like Mike Huckabee. And they sought and won a preliminary injunction to prevent the FEC from enforcing its naming rules. The court here held that the rule was not a disclosure requirement, disclosure requirements being judged by more lenient standards, because it prevented Pursuing America's Greatness from conveying information to the public in the name of the website. And the court further held that titles are important. Without a candidate's name, the title does not provide the same signaling to the audience. Allowing a committee to talk about a candidate in the body of a website is of no use if no one reaches the website. I'll pause to note this may well not be true, given current search engine practices, but courts generally think that this kind of casual empiricism is fine when they do it, and it is everywhere in trademark cases. As a content-based regulation, the FEC rule needed to be narrowly tailored to serve a compelling interest, and it wasn't, despite having the same basic structure as trademark law. The court assumed that avoiding voter confusion was a compelling interest, but it still wasn't narrowly tailored. And I want you to consider typical trademark infringement remedies being held to the following standard. Here, the FEC reasonably fears voters might mistakenly believe an unauthorized committee's activities are actually approved by a candidate if the committee uses the candidate's name in its title. But there's a substantial likelihood that the rule is not the least restrictive means to achieve the government's interest. And it failed because the FEC didn't offer any evidence that larger or differently worded disclosures would be less effective at curing fraud or abuse than a flat ban, or that disclosure requirements would be unduly burdensome. The FEC needed more than anecdote and supposition to support a regulation of this kind, where the record is silent as to the comparative effectiveness of two alternatives, one of which burdens more speech than the other. The more burdensome restriction cannot survive. Consider that standard applied to counterfeits. Now, it's quite possible that trademark owners don't actually need to worry, because their claims are so well accepted that conventional wisdom will carry them through scrutiny that other regulations will fail. I'd consider that a failure of logic and a demonstration of that the current skepticism of regulation among some judges has a distinct political bias, but it could easily happen. So it's possible trademark will escape scrutiny as regulations of other kinds of commercial speech continue to fall. In that case, trademark lawyers should only have the same fears as the rest of us. That without the FTC or the FDA, without regulations on price labels, we're not going to be able to tell what we're paying for, what the amount we're paying for our purchases, or even how, in the end, we're going to pay. So that brings me to the end, and I'm really excited to hear your questions because, as I said, this is just at the beginning, and I'm sure there are some people who had rather violent reactions to at least parts of this.
Do you want to moderate it yourself, or do you want me to moderate?
Actually, if you would, that would be great. I would really
Okay.
appreciate it.
So I'm happy to moderate and take the cue. Go ahead.
Heck, I'm just wondering if you
Nice and loud, please. Outside voices.
So, or inside, Mike. I'm wondering if you'd say a little bit more about rhetoric in its relationship to the fact-finding processes of agencies and judges. In particular, I'm thinking in light of the oil states case, the difference between calling something property for purposes of trademark regulation versus, I don't know what you would call somebody's name for purposes of FEC election.
It's a really interesting question because, on the one hand, I think we don't want the government to be free to completely change the regime of scrutiny by calling something property. And you can see this, there's a historical example. After the flag burning decision in 1989, there was actually a law proposed to make every flag the property of the United States so that somebody who engaged in flag burning would be destroying federal property. This pretty clearly is not an acceptable workaround because of its transparent motivation to suppress speech. Whether other forms of propertization should also fall, especially when they may have other motives than just suppressing speech, is a good question. I am inclined to believe that the recategorization of something as property should not have a particularly significant effect on our First Amendment analysis, at least not without significant evidence that it entails a whole bunch of other consequences. So, for example, with physical property, there are other consequences that come from calling you the owner, including your liability for taxes, for whatever registration requirements there may be. That's the kind of thing where, say, okay, we can, in law, reasonably call that private property. I am less persuaded that labeling an intangible right property should change the First Amendment analysis.
This was a wonderful talk. I really enjoyed it. Thank you. And what was occurring to me as you were talking about the epistemological crisis, particularly as to what you call probabilistic aggregated knowledge, is that this is the era of big data analysis in which that's what's happening all over, right? Probabilistic aggregated knowledge is big data, algorithms, all that sort of stuff. And so that leads me to think, I think, three things. One is if courts are rejecting government use of probabilistic big data kind of analysis, but private entities get to reap all the benefits of doing that, doesn't that cause a huge imbalance sort of between private and public power? That's one. Two, is there going to be consistency in the judiciary sort of against probabilistic aggregated knowledge when it comes to areas like algorithms for predicting recidivism and sort of criminal law stuff? Or are we going to see courts be much more accepting of big data analysis in that area at the same time that they're rejecting it in First Amendment area? And then I guess lastly, being a little more sympathetic to judges, are they feeling some of the anxiety that I think all of us sometimes feel about being treated as just subjects of big data analysis, and whatever we're being presented with on the internet is being presented to us alone for analytical reasons that we have no idea, what they are, how Google or Amazon has gotten to the point of presenting it to us, or how they're trying to manipulate us. And if the judges are feeling that too, then aren't they? Maybe they're just feeling like this kind of that's a little bit anxiety provoking.
So thank you. Those are all great. So your point about the imbalance, because the private entities have no such restraints on using knowledge that they gain to make interventions into the world. is a great one, and it helps, I think, situate us in kind of a replay of the Gilded Age that we are going through, where there are huge entities that have a lot of private power, and there is an ongoing ideological struggle of whether some government ought to in any way be able to address that. And I think it's an open question how it will come out. So the response, though, of I think the fairest, the best case that I can give in that case for the sort of First Amendment libertarianism is to say, well, the government retains its power to ban stuff that's not speech. So we could, in fact, ban credit cards. Right? We don't have to have them, and then we'd solve our problem of credit versus cash discounts. Nobody would be deceived because there'd be no credit cards. Now, obviously, you don't want to do that, but the legitimate insight under that is that government often tries to use speech regulations to mediate a conflict that can't be politically resolved, right? You can't actually ban cigarettes, even though it would be better if nobody smoked them, so you regulate the advertising instead, right? Similarly with alcohol, gambling, right? So historically, that's been a pattern, and it's probably not the best choice, even if it is politically expedient. So the best case for the libertarians, I think, is by taking the advertising regulation off the table, you force real decisions about what we care about politically. Now, in a dysfunctional political system, that's not going to go well, but the information libertarians might well say, like, that's really not the problem of the First Amendment doctrine, right? You need to fix the other stuff. So your second point about the use of algorithms, I actually think that it's relatively likely that courts thinking seriously about this will be highly distrustful of algorithms, whether or not they should be. I think there are actually some good reasons to be distrustful of the ones we have now, given that they're programmed on data that themselves reflect a whole bunch of racism and class distinctions, right? And so reproduce these just invisibly. But actually, the court struck down the sentencing guidelines, or the mandatory aspect of the sentencing guidelines a few years back, because of the same kind of distrust of non-individualized fact-finding. Even though the sentencing guidelines are written by judges, they weren't written by judges, for that particular situation. So I suspect that one at least can be made, can and likely will be made consistent by large-scale skepticism of this sort.
Great. And I'll note that the first three questions are all from the profs. You can tell what kind of law students we were. But law students, we do want to hear your questions. Yvette, please.
Thank you. Rebecca, this was great, and I'm very excited to see where it goes. When you were talking about the factual determinations about where a cow was born and saying this cow was born in Canada, or this cow was born in Mexico, or this cow was born in New Jersey, that can take one further step. I have to, is it infringing on my free speech when I have to say I was born in Rahway? Was I really born in Rahway? Was I born in, in something else? Where is the factual, if we're going to say factual determinations are difficult and it's forced speech on me to say I was born in New Jersey. Should I be compelled to do that? Where do we, with birth certificates, who are my parents? So if they're going to go down this road about we can't say where cows are born, what about citizenship and where we were all born? And if in my heart I am, truly Moldovan, or, how far do we go in terms of how far are the court's going to go if they're going down this road of, well, we can't really determine, we can't force you to say where the cow was born. Can we force people to say where they were born?
Right. Right, and I expect the answer is probably not, right? So I can construct a lot of scenarios. You probably get a compelling government interest in forcing this disclosure in some circumstances, right? But there is something there with voting rights, right? The idea of a particular kind of ID, and transparently, and especially in North Carolina, the ideas that they chose were not neutral. They were IDs that certain groups of people were much more likely to have. But even in the less obviously racially motivated ID restrictions. These are about, there's only a couple of ways to produce the appropriate kind of knowledge. But note, so far the states have largely gotten away with that because of the different way we think about voting rights versus the economic rights of corporations, which I would probably reverse if I could.
Me too, yeah.
Another professor.
Go ahead.
No,
Hi.
please, Alan.
Maybe it's a foreign's view, but I will ask a question more specifically about the First Amendment, because it's really, has this time that I spent here, it's been struck me of like really overgrown, like an overgrown right that like surpasses everything. Am I right that it actually will or is overruling or overgrown to the point that it's dismissing consumer welfare, even like public safety welfare, when you talk about medicine and advertisement and so on? Is it an impression or is it like real?
Right. So absolutely. Americans are often discussed as, distinctive in our free speech traditions around politics, but frankly, we're much more distinctive in our free speech treatment of commercial speech. This is the thing, you're not alone. Many people who have been trained in other legal traditions sort of say, no, really, what does the First Amendment mean? You can't be telling me like an actual system. I will admit to, okay, there is a tradition, because in America we have managed to do everything wrong at least once. So there's a tradition of, oppressing groups based on certain kinds of commercial speech regulation. Usually not ethnic groups as such, although it happens, right? So, for example, there's a clear discriminatory effect of having, training and licensing requirements for hairdressers. And the day is coming when that will be a First Amendment problem. And in fact, there are people making that argument now. Hairdressing is expressive. It's certainly as expressive as making a wedding cake, right? It's a First Amendment problem. And that's not off the wall, right? A part of this, too, is, and Fred Schauer has written really great stuff on this, that basically, when the First Amendment is such a powerful weapon and equal protection is not a particularly powerful weapon, and substantive due process, right, everything starts to look like a speech issue when that's what you have. And liberals and conservatives both have recognized this. So you get, important decisions about gay rights and about African American rights that are framed as First Amendment decisions, when really the problem is discrimination. And so there's been a sort of path dependency that both feeds and is fed by distinctly American traditions. But I think, especially in the area of commercial speech, it's not healthy.
Thank you.
Literally, I guess.
I want to try moderator's privilege. I love this idea that judges have this superior fact-finding ability. I'm looking for a nice test case where I pit the courts against the FTC, and I think, so I'm forgetting the substance, but the form of false advertising under the Lanham Act where you implicitly make a claim. So I'm thinking of the Mylanta case. It's the two antacids and magnesium, right, is added to one. And I think of the comparative advertising is, we have magnesium and they don't, making the implicit claim that magnesium is somehow good for you, when in fact it's not. So that the court decided that was a form of false advertising. But under your thesis, had the FTC brought a false and deceptive Section 5 action, would the claim that consumers would have, that the factual claim would be that consumers would have heard, we have magnesium and they don't, lead a reasonable consumer to think that there's a health benefit to magnesium for which there is none?
Yeah, so I would say absolutely. But that's just so it's not that courts always get it wrong. I mean, right? They're largely composed of smart people who are thoughtful. There are only times, and they happen to correlate pretty strongly with times where expertise is really helpful, that they have trouble. I actually have advocated for the broader use of the idea of implicature. So, so a standard rule of speech is basically don't say irrelevant stuff. And generally, when you're interpreting an ad, you assume that they aren't wasting their, valuable $10,000 a second time on telling you stuff that isn't important. So yes, a logical inference from an ad would definitely be, magnesium, that's a reason to purchase us instead of the competitor. You don't need to know it, but it's there. And, in a world this big, right, you can't know all the stuff about magnesium. You can't know all the stuff about vitamin A. So you have to rely on somebody.
Well, that's what the court said, but if the
Right.
FTC said that, would it survive a First Amendment challenge?
Right. So today, it's hard to say. The interesting thing for me is we're now talking about a kind of different form of knowledge, right? So this is not probabilistic in the sense of statistical or data. It's a standard interpretive move in a conversation, and so it's probabilistic in that sense. We can find violations of the rule of relevance, but it's really linguistic knowledge that matters. And there are plenty of courts that will still defer to the FTC in kind of run-of-the-mill cases like this. Especially if you have a good story about why it's deceptive. So it's not like everything is going away. But I actually think that the fact that we get these sort of weird incursions where the principle seems like it should be enough to destroy the whole FDA, and then the courts kind of pull back from that because they don't want to do that, right? So there's this intuition here, I think that if these claims about fact-finding were taken seriously, there'd be no FDA. That's probably not a good idea. So we're just going to confine it to this situation.
Great, thank you. Peter?
So I like the turn toward epistemological uncertainty as a frame very much, because it seems you get a lot of stuff into that frame and it has a lot of explanatory power. But as I listened, and now also as you've been talking subsequently, it occurs to me that there's sort of two other frames of different dimensions that also seem to fit here. And one, pretty evidently, and perhaps so much so that it really only amounts to a linguistic restatement of this one, is the sort of the decline in faith and expertise, which probably sort of hit its peak sometime in the early administrative state, and has kind of sort of been bumping down the stairs ever since. And the other is, it's more or less coordinate, its rise is more or less coordinate, although there may be no explicit connection, the rise in sort of naive faith in the function of markets, abetted as perhaps in this case by the sort of all its silliness of marketplace and ideas and so forth. So what relationship do you see between those other frames and the frame you've chosen?
So I think the first one is helpful and I think completely consistent with what I'm saying. I will say that it seems particularly hard for a judge to maintain this position coherently, right? That it's antagonistic to the very position in a way that it's not, for Mr. Smith goes to Washington, right? So we have a history of electing people to offices for which they are completely unprepared, and not just a recent history. No, not at all just a recent, but the judiciary has maintained its position, and maybe that's under assault too. But the interesting thing about these decisions is that they are being made by people who have come up in an expertise-based system and think of themselves as experts in their thing. So at the very least, it's an instance of special pleading, right? Only my expertise is okay. And even then, because that ends up being kind of solipsistic, it doesn't work in a judicial system, right? Because it doesn't tell us how the district court should relate to the Court of Appeals, should relate to the Supreme Court. And even if the court is, infallible only because it's final, that's still a form of knowledge production that, in theory, lower courts are bound to follow, right? And I don't think you can do that from a purely solipsistic, only my intuitions are right perspective. In terms of the faith in the function of the marketplace, this is a really interesting question, and it is clearly a component. And it's been a component of First Amendment reasoning and, free market reasoning for, hundreds of years. So you have Holmes saying, let's test the truth in the market, and I'm sure it'll sort itself out. But the interesting thing that you got in the move from Mill, who also sort of did this, to Holmes was Holmes actually didn't necessarily have much faith that the truth would come out, right? Whereas Mill kind of committed to, and the truth will win. Holmes maintained a kind of indifference to that, or at least he said, it's not my job, it's not my department. Where the consensus comes down. And I don't know that this is a different frame so much as an aspect of it. That is, this epistemological uncertainty is about not having a regulatory state. And having a regulatory state is about saying that there's, among other things, there are certain things that make markets function badly, right? So we need to define the duties of the night watchman, even in the night watchman state that only seeks to protect voluntary transactions and seeks to do no more. We need to know what the duties are. And so the commercial speech cases are particularly interesting because in some sense, we are trying to figure out what the night watchman is supposed to do. And it turns out, if you have that much epistemological uncertainty, then how am I to know, right? It's all he said, she said.
We'll take three more. Nick?
Can we be uncharitable to judges for a second? And so it seems like they are not very good at telling good studies from bad studies, and that's making them either hide from issues or make bad decisions about brain pills. And is it too much to ask for them to have sort of a basic understanding of statistics and how a good study is designed and that kind of thing, and use that information to make decisions?
Yeah. It's a great question, and I think it's actually not too much to ask, right? So the FTC, the Quincy Biosciences case, is not about ideology per se. It's about not knowing math, right? And that can be corrected in a way that Chief Roberts' gobbledygook opinion cannot be, because it's important to his self-concept and to his ideology in a way that no amount of additional evidence is going to fix that. And this is the strict scrutiny part, right? Or in the case of the gerrymandering, he wants rational basis scrutiny, so he doesn't care. There are ways to do this. So the Federal Judicial Center does actually run statistical training for judges, right? More of them should do that. And they should also be more willing to listen to, like, here the FTC sort of has an explanation of, okay, this is why post hoc subgrouping is bad, and the court's like, don't tell me that, subgroups are a thing. And that's just, I do think that is correctable, but it does require us, especially as teachers, to say, you know what? You cannot get away from math, at least not from statistics, by going to law school. Like, there are all these people who say, that's why I went to law school, because I really didn't like math. No can do.
Sir?
Yeah. My question is based on that. And so statistics is hard for scientists too. Like, there was the whole scandal with psychologists a couple years And so my question is it different for a legislature or is it or the FTC to say we want you to evaluate these check marks when looking at a study? So check for p-hacking or check that the study does methods before they go for results.
Yeah, this is a really good question, and there are only relative competencies. I think that's absolutely true. But especially for something like the FDA, like they do a bunch of these, right? So it's not just that they're looking at the one in front of them. It's that they are better able, even if not perfectly able, to judge it against the other things that they've seen and say, okay, this is probative enough to be that you should be allowed to make that claim. Versus, and then here's the magical part that I think nobody has fully worked out, although I think the FDA is trying. The other half of why you can't make this claim is consumer misperception, right? So when you say a study supports this, it's very hard for almost everyone to process exactly how much that means. They tend to believe that means it's been proven, right? And it's that part that does the harm, not so much the, reporting, well, there was one study, right? It's the way it's used, and of course, advertising multiplies that, because the reason the advertiser is telling you that is because they want you to think it's been proved. So that part is actually not about the math. It's about consumer perception. And again, there are fields of knowledge that are focused on this, that are done, in probabilistic ways that aggregate large groups, and the FTC and the FDA have access to them in ways that judges generally don't. So I'd still say that there's a relative competency issue about what is often the most crucial part of this, which is how are people going to understand it?
Bob, you get the last question.
Well, and this one may be asking for another speech, and that may be a fine way of answering it. But you mentioned substantive due process as an alternative but less fashionable way to getting to some of the same outcomes. So perhaps expanding on Peter's question, are there any bright lines left between where this seems to be going and simply going back to pre-New Deal substantive due process?
So I think that's a fantastic question. So Judge Kaczynski was recently interviewed about the 25-year anniversary of his very good article on commercial speech and why there shouldn't be a commercial speech doctrine. Completely disagree, but it's very good. He says, so somebody asked him the Lochner question, he says, yeah, Lochner was rightly decided, right? I am completely consistent. I don't like the government doing anything in general. And so he's perfectly willing to apply the same standard. He doesn't care what the name is because he has an idea of what the government should be doing and not be doing. He doesn't want there to be a line. Are there people who do? It's not clear to me. So if you look at, say, things that Judge Brown, who I've quoted from extensively, has written, she would really rather have Lochner too. This is just the most successful edge, right? So the better you get at framing your objection as a First Amendment objection, the more likely it is that you will get some people who think that there's still a remaining role for economic regulation and for deference to the legislature, just not in this particular case, right? So, yeah.
Great. So with that, I would like to ask everyone if they'd please thank Rebecca for this. And now we have an exercise program for you. We do have a reception, but we have to walk together. Our reception is set up in our atrium, which is in the building next to us. So if you come out of the door, you take a right down our long corridor, you go up the stairs, and it's in the entranceway of the Yuma building.
But you don't need to go outside.
But you don't need to go outside.
I think I'm going to follow you.
We'll need you. The Clyde Piper show.
How much food and wine there is.
There it is.
You get twice as much.
Really?